insurrection. It is undermined by unbridled capitalism in Indian country. And we are now in a moment in our history as Indigenous Americans where neocolonialism is causing elected officials in tribal governments to deprive our own peoples and their own relatives of that innate and that inherent right to belong, of their birthright. And as promised, we'll look at today's talk through this lens of critical race theory, or CRT as it's called, but the fundamental concern I have is that Indigenous Americans, the first people of these lands, are the only Americans naturally born to these lands who do not universally enjoy civil or human rights protection. And that's an unknown truth. That's an inconvenient truth, but it is widely unknown within the legal profession and certainly greater society. I'll talk at great length how we came to be here, but it really dates back to a period in the late 1800s when we did not belong as United States citizens, when the prevailing policy of the United States government was to assimilate and eradicate us. And therefore, it was deemed by the Supreme Court that the United States Constitution and its Bill of Rights did not protect us on our own lands. And the concern I have is today, as a matter of CRT, it is tribal politicians who are leveraging these imperialist and racist and colonialist systems and structures to deprive their own people of birthright. And we often talk about CRT almost in a binary way. Some white supremacist organization versus the 1619 Project. Some settler state like the state of Oklahoma versus any BIPOC or minority race or culture in a state like Oklahoma that is seeking to have its history told. But it's important to recognize that CRT also applies internal to us, meaning when our own forms of government, our own systems of government, our own so-called leaders are acting in a discriminatory or racist or colonialist way, CRT is a tool for us to challenge those power structures. So we can look historically at these systems of economics, of history, of context, of group and self-interest over the course of the last 500 years, or as all to today over the course of the last 200 plus years, to critically analyze where we are as Indigenous Americans in this day and age, as it relates to our own peoples, our own nations, and our own societies. And this too is an untold and at times inconvenient truth, which is that pre-contact, the great majority of Indigenous peoples in this country did not self-identify as nations or as governments. We self-identified as kinship groups, predominantly according to a clan system. Now, I will risk generalization today because there are groups like the Iroquois Confederacy that we would consider government or nation, even in their most organic state. But the teachings that I'm aware of, the history that I'm aware of, makes clear that we did not self-identify by and large as government or as nation. Instead, we identified as kinship society, as clan, and as people. And perhaps the most obvious proof of this is if you deconstruct today's names for our tribal nations and perhaps put them back in their original language, put them back in their original context, you will see a great number of Indigenous nations in that context that self-identified through their own language, their own ways, and their own customs, not as the government, not as the nation, but quite simply as the people. And here are a number of examples, including some of the most powerful modern nations in Indigenous America today. And Dean Strickland taught us this in his critical book of 1975, where he looked at Cherokee nationhood or Cherokee clanship, the family writ large. And he concluded correctly that there was no government or nation greater than the people. There was no subjection of the people, no subordination of the people to something in the form of a nation or government that was greater than them. And you see that the Dene, now known as the Navajo, similarly did not historically consider themselves as government. There were categories of the Dene people, and I don't profess to be an expert on any of these nations, but there were categories within kinship and clanship system that set up the structure of the Dene society, but it was not one that was considered to be government, at least in their traditional thinking. And that brings us to this idea of rights. And a core point to be made today is pre-contact and pre-constitution, our societies were not right-based. We did not have an entitlement. We were duty-based. We owed a duty to each other. We owed a duty to our people, to our clan, to our families, and to one another. And it was that duty and that reciprocity, because everyone in kind owed the same duty to the other, that formed the basis for these kinship societies. And Vine Deloria Jr. and Clifford Lytle reduced this to writing in 1984, I think, in a pretty cogent way, explaining that under this concept of kinship society, there was not a concept of what we would call today civil rights, because everybody was related through kinship and through belonging, and it was a matter of responsibility or duty to one another and to the clan, rather than right or entitlement from the clan or from one another. And his auntie Ella Deloria wrote this from New York City in 1944 about what I call kinship rules, meaning just being good citizens and good kin to one another. And again, in very cogent fashion, she explained, and that was practically all the government there was. And there are many tenets or rules of kinship that I don't profess to even understand, but there are two that I'm focused on. Two reciprocal duties that underpin kinship as it relates to my worldview. One, the right to belong, as we would call it today, or what was then the duty to belong, the reciprocity of belonging. And it was very simple. If you were born unto your people, unto your clan, unto your society, unto your homelands, you belonged. And that was as simple as it needed to be. And as she writes in 1944, nobody was left outside. The other tenet is social labor. The idea that when you were working, be it harvesting, fishing, gathering, farming, and let's observe that many of these activities were governed by matriarchs, meaning women, that was done for the good of the group, not for the individual. This idea of social labor and this idea of belonging are two underpinnings of Indigenous society. So how did we get here today? Where authoritarianism, capitalism, neocolonialism are taking hold of our societies and our nations. Again, looking at this through a CRT lens, I'd cite to you Omi and Wynant's crucial work, Racial Formation in the United States from the 1960s to the 1990s, which my mentor, Rob Williams, recommended to me a few years ago. They teach that for the better part of the 1600s and 1800s, for specifically a 258-year period, when it was whites and settlers who were making law and policy, that what resulted through what they describe as a process of racial formation were a series of racial categories that in turn were ascribed racial, social, socioeconomic, and now legal meaning. And I would submit to you this very idea of right versus duty was a product of this racial formation period, as was tribal nationhood, citizenship, enrollment, blood quantum, per capita. These are all settler constructs and settler systems that were imposed upon us when we were not in positions of power and influence. From the colonial era to the new constitutional era to the young federal era. And you can look again at that 250-year period and see these things bear out, where in the 1600s, treaties were introduced. We were called Indians, of course, dating back to 1492, when Columbus stumbled off a boat in now the West Indies and found the Indias. We were described tribes as if we were the lost tribes of Israel in the 13th century. This became common parlance within the settler state by the 15 and 1600s. Racial categorizations, historically and geographically unmoored from reality. Nationhood arose through the form of treaty. The first Indian payroll, and think about a per capita check you may have received from your tribe or your nation, be it a rescue plan check, a CARES Act check, a gaming per capita check. Recognize that per capita and this idea of payroll, and that's what it was called, an Indian payroll, started well before 1988. there's a 200+ year history to these dollars, and I'll explain why they are systematically destroying our people. Blood quantum is often believed to have arrived during the Dawes Act, which is incorrect, or the Indian Reorganization Act. But you actually see this idea of blood, this racial fiction of blood, introduced within the first 50 years of this country's history in treaty. And to be clear, there is no percentage of blood running through my veins that is Nomlaki versus Concal versus Scandinavian versus Portuguese. This is a racial fiction that was brought here by the settlers, brought here from Europe, brought here on what is now a debunked inheritance theory and what later became a debunked eugenics theory. It is a fiction that there is some percentage of blood running through our veins that can be ascribed to particular races. Yet, as I'll talk about later, 70% of our nations and our societies use that as a metric of decision-making as to who belongs. By 1835, the words per capita were being used in treaties, whereas the Cherokee Nation in particular, and those peoples, amidst the Trail of Tears and the horrific conditions that caused their removal from the southern area of the United States into Oklahoma, personal apportioned monies were being offered to Cherokees to basically assimilate into mainstream society. And then you have a law passed in Congress in 1847, which is curious. Why would treaty monies, having been negotiated over the prior 50 years with nations, suddenly be paid to heads of families and individuals rather than the heads of nations on behalf of their people, if not perhaps to divide and conquer those people? And I'm sure you've all learned about the Marshall Trilogy, the foundation of modern federal Indian law, a foundation that is rotten at its core. But words that are often overlooked from John Marshall affirm what I'm saying, which is that this idea of treaty and this idea of nation, he says these are our words, selected by us in our proceedings, having a well understood meaning to us. We have applied them to the Indians. Again, the great majority of us did not self-identify as nation, which isn't to say we weren't self-governing or self-regulating, but these words are settler, colonial, and federal words, not our words. And we have adopted them as if they were always our own. But the fact of the matter is, treaty making in particular was basically a ruse to dispossess indigenous peoples of their homelands. As Professor Williams teaches, it was idea that under then generally accepted international law principles, through entreatying with other nations, you could justify the dispossession, or as the Supreme Court said it at the time, you could justify dispossession of the continent as if it were conducted in perfect good faith, rather than amid genocide, termination, and assimilation. And so how did we get here today where we consider ourselves nations and citizens? Well, I'll explain that as well, but Dr. Kim Tallbear, in an essay she wrote not too long ago, quotes a young man from First Nations country, a Saskatchewan man, and I think it translates well, notwithstanding the fact that it was said above now this artificial line, the United States-Canadian border. But fundamentally asked, citizen, nation, where do these concepts come from? Are these our concepts? Are these being spoken in our own language? And Kim Tallbear wisely asks, are these the best conceptual frameworks for organizing our decolonization, for our recommunalization? Or is there a better, less incoherent way for us to begin to speak about our belonging and our self-identity, whether as a group or an individual? And Frantz Fanon writes this, which I think is apt, suggesting be very careful about the language you do in terms of yourself, the language you deploy in terms of your self-identification, because that language translates into an existence, whether expressly or implied by those words. So now looking past 1865, we were introduced to Indian enrollment through the Dawes Act. Now censuses had been created, especially with the Oklahoma tribes, for the greater part of the 1800s. But you now have this idea during an assimilation period where we end up being listed as enrolled citizens or members of tribes, which was not an indigenous construct. There were not lists pre-contact. There were not lists pre-constitution. Now we are on lists. And then what arrives within 30 years of that were this idea of disenrollment. This is the first reference I can find to this word, which of course has no mooring whatsoever in Indigenous custom or tradition. This is a modern problem, which I'll explain in great length. But you can look back again to this period of assimilation where Congress is using words like disenrollment as it relates to the assimilation of citizens or members of tribes. By 1919, the Interior Secretary was bestowed by Congress plenary authority over enrollment. And this law is still on the books. So Secretary Deb Haaland, first Indigenous Secretary of any department of the United States, sitting here today under this statute, has plenary authority over the roles of almost every nation in this country. There are a handful excepted from this particular law, but today's United States government will act as if they have never been involved in enrollment, never been involved in disenrollment, never been involved rightly or wrongly in the decision of who belongs to an Indigenous society or nation. The fact of the matter is they created it. They created the entire system, again, during this period of racial formation. And there's a lot of talk now about political classification, especially given Berkeley, which I'll talk about. It can be a racial category and a racial formation, and we can still have political existence, nationhood, and political classification. These things are not mutually exclusive. The point is to recognize the origins of these systems as being colonial and racial in nature. By 1934, the IRA defined an Indian as someone who was of half Indian blood, again, according to this fiction. Then inheritance theory. And you also needed to live in residence on an Indian reservation. By 1968, which I'll talk about, the Indian Civil Rights Act was passed. And in 1978, which I'll talk about at great length, Santa Clara Martinez was decided, which is, in my estimation, the worst Indigenous human rights case ever decided by the United States Supreme Court. And that is saying something, because there are 200 years of horrific tribal or Indigenous rights cases that have been decided by the US Supreme Court. This idea of rights took hold in Indian country, again, by virtue of treaty and now laws that had been passed over the course of 200 years. And by 1968, authoritarians began to rule Indian country to the point where tribal members were crying to Congress, women from the Colville Reservation in particular, crying to Congress about how their rights were being violated by autocrats. Congress made an informed decision that the first Americans of these lands should be protected by some Bill of Rights. It was then called the Indian Bill of Rights or the Indian Civil Rights Act. There should be fundamental freedom protected even in Indian country, notwithstanding that Talton v. Mays decision of the late 1800s, when we again did not count as American citizens. Enter Julia Martinez, a Santa Clara Pueblo woman who arrived to the Supreme Court in 1978. In 1941, Julia attempted to have her daughter, Audrey, I think she was then around 2 years old, enrolled in the Santa Clara Pueblo of New Mexico. And at that time, a newly formed IRA council, all men, had passed a law in 1939 that said, if you are a woman of the Pueblo and you have a child with a man who is not of the Pueblo, your child does not belong. Your child is not eligible for citizenship. There was no law, however, that said, if you are a man of the Pueblo and you give birth to a child with a woman who is not of the Pueblo, that child does not belong. It was a patently discriminationist law, patently violative of equal protection. But again, the 14th Amendment didn't apply to Julia Martinez on her own lands because of that decision in the late 1800s, and notwithstanding the Citizenship Act of 1924. So she went, after making rounds with Congress, rounds on her own Pueblo, round and round and round, she ended up before the United States Supreme Court in the late 60s and early 70s, after going to trial in the United States District Court, after heading to the 10th Circuit Court of Appeals. And by 1978, she arrived in front of what are called the Brethren, 9 men sitting in black robes, 1 black man, Thurgood Marshall, and 8 white men. And they decided that the Indian Civil Rights Act of 1968 did not give her a right to sue tribal officials for prospective equitable relief in federal court. There was no private right of action. Sovereign immunity was asserted by the Pueblo and was ultimately affirmed by the US Supreme Court. And in that moment, the Indian Civil Rights Act was gutted. And I'll explain to you why in a few moments, why today it is dead letter. It is not a statute that carries any meaningful weight as it relates to Indigenous human rights protection. And those 8 men, or the Chief Justice at the time, handed the pen to Thurgood Marshall, of all people, who the year prior, in one of his landmark decisions as it related to prisoners' rights, said it is a fundamental right to access federal court for constitutional protection for prisoners, perhaps the most disenfranchised people in our country. Right? There is no greater icon in the civil rights movement than Thurgood Marshall. I've listened to the audio, and he seemed awfully concerned about cultural sovereignty, which I don't begrudge whatsoever. In a Southern drawl, he said, the culture, as he peppered Julia Martinez's lawyer with questions. He was concerned about cultural sovereignty. But neither he nor the other 8 men on the court, I think, really understood what that case was about, which I'll explain in a few moments. And what I want to spend a significant amount of time is talking about this movement in Indian country, what I dub per-capitalism. And I've already alluded to the first payroll that I can find in my research was 1790. I've alluded to the 1835 personal apportionment of money, to the 1847 law suggesting, as a matter of division and conquering, that monies could be paid to heads of families and individuals rather than chiefs of tribes or heads of nations. In 1907, a companion law to the Dawes Act being the great pulverizing force, according to the president at the time, where millions upon millions of ancestral homelands were taken from Indigenous peoples. There was a companion law that said, if you're a competent Indian, you can receive on a pro rata basis trust funds that the Treasury Department had on account on behalf of your nation. The idea, if you make the land divisible, if you make the money divisible, you create more more right and entitlement in individuals, you will decimate the people. You will decimate the society. And that's, by and large, been successful. 1978, I'll come back to the case Santa Clara Pueblo versus Martinez, but you see time and again throughout the 80s, most notably the Indian Gaming Regulatory Act, where per capita distributions were authorized by Congress, emanating now from a nearly $40 billion casino enterprise. You see Congress authorizing the distribution of these monies to individuals, I believe, without full appreciation for the insidious effects of those dollars on those people. $35 billion was allocated to Indian country through the CARES Act and the Rescue Plan, a once in a generation, if not a once in a lifetime investment in societies and nations that in many respects are still in third world condition. And the great majority of those monies, it turns out, were distributed to per capita payments to tribal members. So those monies did not go into a new health clinic, into a new gymnasium for kids, into a new school, into new infrastructure. The better part of $35 billion as a matter of right and entitlement within our communities was distributed to Best Buy, Foot Locker, and to Amazon. So how did we get here? Well, let's get back to Santa Clara Pueblo versus Martinez. Why was that 1939 law passed? Well, in the 1920s, that Pueblo engaged in a land settlement with the United States, righting a historic wrong that land had been taken and money were paid to that tribe. There was a massive infight in the 1930s that caused the BIA to come in and impose the IRA on the Santa Clara Pueblo as a part of sort of stabilizing the government. And by 1939, the men on the Pueblo Council were concerned about people off the reservation. Again, the IRA has this residential requirement at the time, absorbing resources for those that lived on the reservation. In particular, they were worried about monies being distributed on a per capita basis to tribal members. Again, this is not a concept from 1988. This was the underpinning of the 1939 law that was discriminatory on its face and prevented Julia Martinez from enrolling Audrey. And until the day Julia died, Audrey was never enrolled, despite the fact that she was fluent in Tiwa, fully reared in the culture, fully reared in the religion, fully reared in the politics of Santa Clara Pueblo versus Martinez. This is an excerpt of the brief where Julia Martinez's lawyer was trying to get the Supreme Court's attention, explaining the reason this law was passed, Your Honors, is not because of cultural sovereignty. This is about economics, and this is about concentrating wealth to those living on the reservation, notwithstanding the forces that were pulling people of Indigenous ancestry and belonging off the reservation at that time in an acute way. This is a bench memo from someone in the one of the clerks of the Supreme Court. It's the only reference I can see where the Supreme Court was told of evidence in the trial court record that this ordinance was designed as an economic measure to limit the number of persons entitled to share in tribal property and income. Everything else about these briefs, everything else about the oral arguments focused on cultural sovereignty, to the credit of the lawyers who in my mind obfuscated what was really before the court. And none of those 9 men, in my estimation, were savvy enough to understand what was really happening to Julia Martinez. We're all a product of our times. I'm not suggesting anything to besmirch them. But what was really happening to Julia Martinez and Audrey was economic discrimination and sex discrimination. And what won the day was tribal sovereignty and cultural sovereignty. And I'm not suggesting that is an entirely bad result, because that case has served to keep states out of tribal business for the last 40 years. That case, however, has also caused a great number of tribal politicians to persecute their own people. Vine Deloria wrote within 6 years that the Indian Civil Rights Act had kept them in check for some period of time, and now they had baldly underestimated the powers they possessed as the leaders of nations, and they could be much bolder in what they wanted to do to ensure their political longevity. And Justice White writes in dissent, how could we entrust the very people who are hurting Indigenous people, who are taking their rights from them, to enforce those rights in an honest way? And this ended up being a pretty wise prediction, because now 50 years later, nearly, there is no legitimate basis for anybody who is aggrieved to go to tribal court and obtain any remedy under the Indian Civil Rights Act. What you must do, if the only remedy you could obtain is habeas corpus, you must go there first. But an autocrat who is going to steal your birthright or not enroll your child is not going to stop there. In my estimation, and you can read the horrific fact patterns of these cases that were decided this year by courts in the West, they will make sure that the tribal court is not independent. They will make sure that the tribal habeas corpus petition is never heard. They will make sure that there is no ability for a federal court to ever review the facts of the case as a result. So the cold reality, in my estimation, is because of Santa Clara Martinez, because of exhaustion doctrine, and sadly, because of the misuse of tribal self-determination over the last 50 years, federal Indian Civil Rights Act are dead. And in a footnote that I don't think Justice Marshall could ever appreciate its effect, he wrote this, footnote 32, the judiciary should not rush to create causes of action that would intrude on these delicate matters. Of course, that was the enrollment of Audrey Martinez, and whether there was a right under the Indian Civil Rights Act to go to federal court to have it redressed. That idea of delicate internal matters has been turned into the watchword by tribal politicians and autocrats and their lawyers and lobbyists and Congress folk and governors and department heads who would rather not get involved. If I had $1 for every time I heard internal matter, it's an internal matter, I would be long retired. For the last 10 years, having embarked upon this work, I have heard it on almost daily basis from tribal officials, lawyers, lobbyists, state and federal officials, judges. This has become the watchword. And the results are catastrophic, especially in the context of disenrollment. But under banner of Santa Clara Pueblo versus Martinez and that footnote and this dogma of internal matter, horrific things have happened to Indigenous peoples. The idea that one's treaty, the descendants of a treaty signer could be disenrolled was an idea considered by one tribe before their Court of Appeals rebuked that concept. The bottom headline refers to a situation where at the Redding Rancheria, my friends, the Foreman family, were actually asked to exhume their ancestor for DNA testing. And with a proverbial gun to their head, exhume your grandma or you don't belong, and then have her remains tested under some pseudo-scientific measure of belonging. They did so. And then when there was a 99% plus certainty that they shared the same DNA as that ancestor, they were disenrolled anyway. That is how horrific these situations are. So these internal matters, as they're called, are neo-colonialist. Let's be clear about it. This idea that 70% of our nations would use a racial fiction of blood quantum to decide whether our children belong is neo-colonialist. The idea that 90 tribes, 15% of those federally recognized, would disenroll 10,000 of their own relatives, that would make that swath of people one of the largest nations in the United States, meaning indigenous nations. That's neo-colonialism. This is a quiet but inconvenient truth. The fact that a great many tribal nations are not enrolling their children or their grandbabies is neo-colonialism. And this fixation on these per capita dollars, in particular gaming welfare dollars, as I call them, is also neo-colonial in nature. Let's talk about the insurgence of these per capita dollars, again, dating back not to 1988, but to 1790, and spanning all of these periods in time when we were under threat as a matter of federal policy of assimilation or termination. They have become indomitable forces in Indian country. And you can look to the Merriam Report in 1928, which gave rise to the Indian Regularization Act of 1934, where you started to see that per capita payments were eroding this kinship tenet of social labor. Tribal members were no longer seeking employment. They were no longer engaged in labor that would benefit themselves, their families, or the group. And the federal government at this time pointed in particular to these per capita dollars. By 1983, take this with a grain of salt. This is the Reagan administration. Maybe Dick knows something about that group of characters. But you see the same theme of what they called social welfare dependency, where these per capita dollars were continuing to erode the idea of labor, and in particular, social labor. And is it any wonder that in 2022, despite a nearly $40 billion Indian gaming industry, and even the infusion of some of those large tranches of federal money, that we are still seeing Indian country suffer from higher than normal levels of unemployment and poverty. And we are now seeing, as we saw with that image of tribal members fighting in the back room of a casino that was titled Tribal Insurrectionism, you see violence catalyzed by those per capita monies and related human rights abuses. And you see disenrollment. And one of my mentors and his wife, Dr. David Wilkins and Shelley Wilkins, have written a book, and they have put their finger on the but-for cause of disenrollment. Again, 90% of our nations doing this to their own people, 10,000 relatives being thrown away. And the but-for cause are these per capita dollars. And a very recent study now shows that there is statistically a greater likelihood of a disenrollment episode, as it was titled according to researchers, when gaming money is involved than when it's not. And that's just one side of the coin. The other side of the coin is, again, a great number of our nations are no longer enrolling our kids and our grandbabies. And a scholar revered in this particular state sanctioned this in an article she wrote nearly 20 years ago, suggesting that maybe that was the proper solution to the challenges facing modern nations. She also described disenrollment as overblown. And unfortunately, those type of words in these type of settings by those type of scholars just give sanction and license to autocrats to do what we are now witnessing them do. I like this passage because it's very apt. Faced with this inconvenient history, the first defense is silence. And who's sitting silent? Sadly, the great majority of indigenous legal academic programs are sitting silent. I commend you all for having me here today and even putting this on a Berkeley law placard, because there is a great number of tribal law programs that would not do that. Why? Because they are afraid of biting the hands that feeds them. In this day and age, you cannot run a successful indigenous studies or legal studies program unless you are relying upon outside money. And the likely affinity for that money is with tribal nations. And the disposable income available to programs in law schools are from casinos. Those same dollars that undergird the human rights abuse are necessary to fund today's Indian legal establishment. So those professors, and I don't begrudge them, it's just the reality, they are not going to bite the hands that feed them by teaching this stuff. Because then there's no tribal law clinic. There's no trip to FedBar. There's no other things that are necessary for these programs. That's the predicament we're in. And the same goes for every single intertribal organization of any prominence in the United States. 2 years ago, the National Congress of American Indians, which in 1944 was formed in part as a civil rights organization, for the first time passed a resolution that recognized this fundamental right to belong to our nation. 76 years it took the Indian Congress to recognize the most basic right of the people to belong, which underpins everything that is sovereignty and nationhood. There is no sovereign and no nation without the people or the citizen. And what happened to that effort? Nothing. It died a quick death because the people that then assumed control over the National Congress of American Indians are complicit in the human rights abuse that I'm describing. No action has been taken to form a task force that at that time was waiting for Brett Keane to come down the line and to ready the National Congress and tribes to defend against that existential threat. Silence is complicity. 2 weeks ago, 50 to 70 disenrollees from around the country attended the National Congress of American Indians annual meeting in Sacramento. Just like you might have seen at Alcatraz or Wounded Knee or Washington, D.C. back in the day, activism that is the basis for self-determination as we know it today was being deployed in a respectful way by our relatives. What happened to them when they approached the National Congress about this purge or this scourge? They were locked out of the building and had the police called on them. And you all probably heard about Brackeen last week, and I'll just reflect on a few things that I've read about that case. The ACLU cited disenrollment, a neo-colonial practice to defend against an existential threat to our existence. And then throughout the rhetoric espoused between Gibson Dunn, lawyer for the plaintiffs, and a ardently conservative Supreme Court majority, you hear words of blood and race. Because again, 70% of our nations have engaged in this racial fiction. So why wouldn't they seize on this to suggest that Indian child is a racial classification? And then you heard this ignorance from Justice Alito that somehow it was relevant on an intertribal preference basis that tribes historically warred with one another. But because the work was never done under guise of that task force, the hard truths are not being talked about, I believe we Indian country were caught flat-footed. I would have responded that, yeah, the Cheyenne people were warring people. And you know what happened to their war captives? They were adopted in as clan members, indistinguishable from anyone else in their society. But because we will not move off of this idea that we were kinship society and we ascribe to this idea that we have always been nations, and we will not recognize the inconvenient truths about blood quantum, we were ill-equipped, in my estimation, to contend with that full frontal existential threat against Indigenous identity and existence. And the only party in the courtroom that was talking about kinship was the United States government, not the tribes. And I'm not an equal protection lawyer, and I don't know if it made sense or not in the face of that assault to talk about kinship. But by mistelling history or ignoring the truth of our history, I think we are doing ourselves a disservice. And it at least occurs to me, as the Solicitor for the United States said, kinship is how families now function in terms of placing kids in need. There is a widely accepted family welfare principle of kinship. It occurs to me we've always had that, but we were afraid to talk about it. So what's that incoherence turning into that Kim Tallbear warned us about? Well, the president of NCAI was on the steps of the Supreme Court yelling or shrieking, "They don't get us." Well, is it any wonder they don't get us? When we're not speaking our own truth, when we're not being honest about our own history? The fact of the matter is, Indigenous kinship, reciprocity, and duty have eroded. And this idea of rights foisted upon us during that racial formation period and ever since have become zero-sum games. We are now witnessing exclusion, violence, and internal oppression. But that's where you come in. the next generation of Indigenous lawyers and advocates. I'll cite to you the ideas that I have for what I call kinship renewal in the face of the demise of Indian civil rights, for the rise and renewal of some notion of Indigenous human rights through what I call relational sovereignty. And to be clear, we can't go back in time. To do so would be suicidal. And I will say, this idea of decolonization is noble, but if you're going to decolonize, that means you're doing away with treaties. You're doing away with nationhood. You're doing away with citizenship. We can't do that. So we need a better term for that. Re-indigenize, recommunalize, maybe that's something your generation will come with, but we cannot do away with the nationhood model that's been foisted upon us, notwithstanding the fact it is a racial product of racial formation and categorization. But we also cannot continue to perpetuate these neo-colonial systems and structures that are now causing us to do what the settler couldn't do, which is kill the Indian and save the man. So my idea is that we infuse traditional kinship tenets and rules into modern nationhood. Our nation should consider going back to their old names. Again, language being our implied or express existence. Kinship systems should be restored. In some way, tribes should reinstill this idea of duty and reciprocity rather than right or entitlement. Fictional blood quantum must be contended with. There's no easy answer here, because no matter what metric you use to establish the baseline for belonging, it's colonial in nature. It's a roll. It's a census. It's an allotment record. But there must be something better than bootstrapping those metrics to blood quantum while our kids are no longer being enrolled. I suggest we renew kinship terminology, speaking of each other as kin and relatives rather than citizens and members. To the extent that we are a rights-based nation or rights-based organization, there should be Bill of Rights protection. And I think you can reconcile duty and reciprocity with right in some fashion, as long as kinship is the underpinning. Disenrollment should be outlawed everywhere. It should not happen, period. If you're a natural-born American citizen, the 14th Amendment says, perhaps with our exception, you belong here, and there's nothing the Congress can do to take your birthright. That should absolutely be the case under our laws. You should not ever be subject to having your birthright stolen. Enrollment moratoria must be lifted. If we are not enrolling our children and our grandchildren, there is no 7 generations. There's nothing to speak of in terms of our future. And while there's reason to believe that guaranteed or basic income might work in non-Indigenous society, I think because of the acute problems that per capita monies have caused our people, I think per capita monies should stop. And the Mashantucket Pequot are a shining example where they have stopped per capita monies and put those monies back into communal programs, and their nation has grown stronger. All of these things are way easier said than done. They are very difficult, but they can be accomplished if there's the appropriate will of the people. And again, this is where you come in. My generation is not going to be convinced of what I'm saying. My parents, our parents and grandparents are not going to be convinced enough to make changes in the status quo. It is your generation where my hope lies. It is your generation where the planet will be saved. It is your generation where we saw last Tuesday our democracy was saved. It's not my generation. It's not my parents or our grandparents. My hope lies in you. My hope is that you will figure out how we as peoples will renew our old ways and our kinship systems and reconcile them with modern nationhood. And with that, I'd be happy to answer any questions you may have. It's been the truest honor to be here with you today and share my thoughts. Thank you very much.
Thank you so much for joining us today. In passing, you briefly touched on political citizenship and the racialization. And you made a comment about mutual exclusivity. And I was wondering if you could return to that point and perhaps elaborate on this within the context of Refugees Holland again.
Yeah, so in suggesting that nationhood, treaty, citizenship, enrollment are products of racial classification or formation, at least according to the critical race scholars, I'm not suggesting that's mutually exclusive. of the political relationship that our own nations have with the United States, or that we have with our own nations. The point is, during that period of time of imperialism and white supremacy, those were all racially based categories. And over time, they have evolved. And we can now say, based on the same system that is the US Supreme Court, according to Morton versus Mancarry, and the same system that is the US Supreme Court that has affirmed nationhood, that we are nations and we are citizens, and we do enjoy that political relationship, that classification. But we don't have to ignore the racial and imperialistic origins of those things in the process of asserting that status. That's my point.
Thank you so much again. It's been a pleasure hearing you talk and then getting a chance to have dinner and discussion last night. I wanted to pose a hypothetical if I could. I was thinking a lot more about Indian Civil Rights Act, and hypothetically, what if that was, given new life and there were process of action? Would you not worry, given how conservative the judiciary and the Supreme Court has become in recent decades, that could be another mechanism by which opponents of tribal sovereignty could attack the validity of tribal government decisions about federal citizens?
Yeah, it's a great question, and it speaks to tension that I've faced internally. So look at Santa Clara versus Martinez, where I can say, yeah, they hid the ball from the Supreme Court, including a hero in the civil rights movement, and Julia Martinez suffered as a result. That could happen in any federal court. Any judge could be fooled to think that something happening in our own communities is or isn't really happening. So there's always the risk of injustice, and there's certainly risks that conservatives, like those in the Supreme Court or that have now been packed in the circuit courts, could further erode tribal sovereignty. On the other hand, however, there's no relief whatsoever for somebody like Julia Martinez and Audrey Martinez. And you see what's happening in our own systems, our own neocolonial systems, causing great suffering, disenfranchisement, exclusion, exile. So there's tension there. I come down on, I believe every Indigenous person who's being aggrieved by any government deserves a right to be heard. And even if that's in federal court, I'm okay with that, because in particular, if there is federal court oversight, it might deter the persecution from happening to begin with. What we saw from 68 to 78, I believe, is Indian civil rights plaintiffs were going to federal court, and there was the possibility of redress. It's my sense that there was less persecution. And then you saw Vine Deloria say within years of 1978 decision, of course, it was, on with it. It's my belief that if there was a United States District Court looking over the shoulders of tribal autocrats who are stealing birthrights and committing human rights violations, they might think twice about doing it to begin with. But I completely recognize that those same judges and that same judiciary could eventually do more harm than good to Indigenous America.
So we have a few questions from Zoom. I'm going to read out names that ask them. I'm just kidding, that one got into it. So the next one said, you mentioned the task force and NCAI. Was that an actual possibility that was never followed up on, or
it's not only a possibility, it's still a standing resolution of the Indian Congress. And the Indian Congress only acts if it has a resolution on the books. It only takes a position legally or politically if there is a resolution. So it is the law of the Congress passed 2 years ago that our birthright matters and that a task force should be devised so tribal leaders can discuss these issues of belonging and citizenship and membership and disenrollment and enrollment moratoria and blood quantum and kinship. But unfortunately, it has, I believe, been put aside, for lack of a better word, by politicians in control of the National Congress, because they're complicit in the violations that I'm speaking of. And it's not just NCAI. I have cried to every significant national intertribal organization for assistance or support, and to an organization, it's an internal matter and we won't get involved. And these are great organizations doing heroic work for Indigenous peoples, without which we would not live in the state that we live in. but to an organization, they simply will not get involved. And why? Because they are also dependent on the same dollars that undergird the human rights violation. And without those dollars, they do not function in providing legal or political advocacy for Indigenous peoples, be it women's rights, voting rights, or other rights.
We have another one from Zoom. How would you recommend that tribal court systems best influence the federal court system? If you do advocate for more federal oversight for improvement of rights, where do you believe that a task force can be most effectively housed? And how would you balance that with any desire to maintain sovereignty outside of it?
Well, you would think the task force is appropriately housed at the National Indian Congress, which everybody looks to for sort of political guidance. And the purpose of that task force is to just catalyze conversation. Because you can go to these conferences of all these organizations that I'm talking about, and you're all going to go to FedBAR, and I'm going to predict to you right now, these issues will not be discussed. And I've been around that organization for 20 years, and they've never been discussed. Because of the politics and the relationship that are undergirded by the same dollar. So you would think it would be the Congress, but the problem of this whole thing is there's no intertribal conversation. So whether it's violence against women, or tribal law and order, or any other movement or cause in any country, it is that intertribal collaboration and conversation led by the Indian Congress and other organizations that causes change and progress. And it does not happen at any of these organizations. These issues are taboo and they're not being spoken about. And that's why these neo-colonial cancers are spreading. As to tribal courts, the dissent in Santa Clara was correct. The tribal court is only as independent as the government itself or the politicians that are leading the government. The only instance where we've had any success whatsoever in stopping a disenrollment or human rights violation is when there were judges appointed to a court of appeals for a tribe that were not dependent on their paycheck. Indian law professors who are interested in justice, not survival. But to the extent your judge or your appellate judges or judiciary is dependent on a paycheck from the people that are causing the persecution, it is hard to imagine how tribal court will provide any relief to people being persecuted.
One more, and then I think we can now question on your students.
Yeah.
So as somebody who isn't Indigenous, didn't kind of slip their head and all before today, I think like I and a lot of probably well-meaning but not well-read people would think that the things to push for before this talk would be words like tribal sovereignty, tribal independence, investing in the nations. And I'm curious, like how you would approach somebody who means well but isn't, caught up on the history so much or the authoritarianism and political issues, and thinks that this enlarges the power and sort of the abilities of Indian people to advocate for themselves. But doesn't realize the doing so. I'm just curious how you have that conversation.
Well, first, thank you for being here and just being open to my thoughts. I think that's what we need, really, is not just the Indian law students or the Native American or Indigenous students, but a broader swath of the next generation of lawyers and judges and politicians and presidents and governors to pay attention to these particular issues. And I don't know that I have a good answer to your question other than we need to draw upon a broader audience of people that will care about that inconvenient truth, which is that the first people of these lands are the only Americans of birthright that don't universally enjoy that right or any other human right in terms of its guaranteed protection. So I have to think more about your question to provide a more cogent answer for you, but thank you for being here. I guess the one thing I will say, and I'll just exclaim it, is in terms of tribal justice systems, tribal bills of rights are necessary. And I think that's one thing that you would think as an exercise of sovereignty and self-determination, and maybe the protection of the individual right, again, now that we're rights-based, is one of the highest and most powerful exercises of sovereignty and self-determination. You are ensuring the future of the sovereign and the nation through the people and their protection. That is something I would like to think that any intertribal organization or any American Bar Association or any legal program could advocate for, which is an enhancement of justice systems in Indian country. Bills of rights and other civil rights laws should be passed, at least as a starting point.
Alrighty, we got one last one. I have Zoom text, I got all kinds of stuff. So the finale question we'll have for today is, for those of us facing potential disenrollment, what would you suggest we do?
I wish I had some good advice for you, but I've been faced with that question for a decade. And I have tried everything that my law firm and I could conceivably devise. And that is drawing inspiration from RBG and drawing information from Justice Thomas and their own realms, how they had building block cases that they worked through the federal courts and arrived at decisions that changed the landscape of America. And I cited to you the 9th Circuit case that we lost this year and the 10th Circuit case that we lost this year, and we lost a Washington State Supreme Court case not too long ago. And I don't have any advice that could give you any hope. I would never have you quiet yourself. I would never have you mute your own voice. But the fact of the matter is, if you are being persecuted through disenrollment right now, barring the situation of the independent court of appeals for a tribe, for example, there is no hope for recourse. None. And I think I'd be doing you a disservice in giving you false hope. So I apologize for being so blunt about it.
That is good. All right, so I'm noticing the time. I don't want to hold anyone here longer. People on Zoom can still submit questions if you'd like. We can open for a little bit. We can answer them alternatively. But other than that, we can get a very, very loud interview.